Number 135, matter of the Honorable Alan M. Simon. Thank you.
Good afternoon, Your Honor. May it please the court, my name is Lawrence Mandelker. I represent the petitioner. May I introduce my colleague, Eric Moss, who is in this courtroom and before the court for the first, and I hope of many times in the future.
As do we.
I'd like to reserve 1 minute.
Certainly.
Our judicial system is bottomed on the public's respect for the judiciary as a whole and its perception of each judge's ability to serve as an impartial arbiter. And that's why a higher standard of conduct is required from a judge than from a non-judicial officer. Even one instance of certain types of judicial misconduct, fixing a case, trampling on a litigant's fundamental rights, racial prejudice, bias, favoritism, self-dealing, so prejudice the public's perception of a judge's ability to serve as an impartial arbiter that they result in an irretrievable loss of public confidence in a judge's ability to carry out his or her judicial responsibilities.
Counsel, did your client concede the conduct and the findings of the report? And talk to us about how that goes toward respect for buildings, respect and confidence in the judicial system.
That's exactly where I am.
Yes, please, specifically.
So, Judge Simon's conduct vis-a-vis the intern, Maxery Joseph, was unacceptable and requires the imposition of a public censure, but not removal. Here's why. One, it was not motivated by bias, favoritism, prejudice, self-dealing, or corruption.
What does that have to do with public perception?
Because those are the things, Your Honor, if you look at the cases where removal has been approved by this court, has been ordered below, approved by this court, they all involved the type of things that I talked about: self-dealing, bias, favoritism, that irretrievably broke the public's confidence in an ability to get a fair trial should they bring a litigation before that judge or before the judiciary as a whole.
Were there findings that Judge Simon testified falsely?
There were findings. There were findings, and that is certainly an aggravating factor. I wouldn't tell you that it's not an aggravating factor. But if you look at the record as a whole, that his misconduct, particularly for Maxery Joseph, I'm separating out Maxery Joseph and the rest.
Excuse me, why doesn't reference to a public official as part of the Haitian mafia suggest some type of bias that the public might worry will infect the judge's conduct in his official capacity?
Yes, Your Honor. First of all, that was not the theory under which the commission brought.
I'm asking. They certainly referred to it and found that he had said this, so I'm asking.
The answer is, if you look at his re-election as a village justice, where he got 50% of the vote in a three-person race, his re-election as a town justice, where he got 99% of the vote, 70% of the village of Spring Valley, his appointment as an acting lead justice.
If a judge refers to a particular group based on ethnicity or national origin as part of a corrupt enterprise, do you think that somehow makes the public suspect that they harbor a bias?
I think that the public could, but it is weighed against what happened to the public in this case.
Counsel, could you
And that's
go-
what you have to balance. Sorry,
Could you
Judge.
go back to, you mentioned you look at the record as a whole, but you then you separate what happened with the intern, Mr. Joseph, from the rest of the conduct that the commission looked at and made a determination about. Why?
Because my argument is slightly different between the two, because I think that the incident with Mr. Joseph, the commission argued, commission counsel argued before the commission, that that incident in and of itself should have been insufficient to justify his removal. So that's why I want to address that separately and then address everything as a whole. And that's the reason.
I think what you mean, it was sufficient to remove him as a whole. Isn't that what you're saying, not insufficient?
I meant
Yeah,
sufficient.
that's what I thought. I understood it that way also.
Thank you, Your Honor. I was trying to slip that by, but I didn't
Listen,
succeed.
the appropriate remedy that you're arguing for is censure, right?
Yes, sir.
There is a series of incidents in this case. There's 6 different charges, but this case is most similar to the matter of Restaino. You're familiar with that, Niagara Falls City Court Judge.
I am, but I think, yes, I am.
In Restaino, he put people in jail. Here, as I understand your argument, he did not put anybody in jail.
That's correct. Restaino,
Let me just say,
Yes.
get to the point. Anyway, the point being is that, is it fair to say the only reason no one was put in jail here during a series of outbursts and a series of people being held in contempt is because the sheriffs or the court officers refused to execute those orders?
I'm not sure about that, Your Honor. In Restaino,
I count at least 6 different times that people were threatened with contempt.
yes, Your Honor, but in Restaino, on-the-bench conduct, rights of
I
litigants.
think you may be right. Restaino may be worse
Correct.
than what we saw here.
And here-
But let me finish. But Restaino
sir.
was one incident, and that judge unfortunately had to be removed. This involves a series of interests and incidents and a pattern of behavior over time. While there wasn't anyone incarcerated, it's kind of a situation of there but for the grace of God, because the officers wouldn't obey the orders, and in Niagara Falls they did.
Except for one thing, Your Honor. The pattern stopped. The pattern stopped spring of 2014.
How do we know it won't start again if something triggers his feeling of, of things not being done well, or people being crooked, or whatever his personal thoughts may be?
If Your Honor will just bear with me, I don't like to answer a question by asking a question, but I have to ask a question to make the point of my answer. Let's assume he served in Ramapo, no problem, the whole time. He served 2 years in Spring Valley after the last incident. No charges, no nothing. So the question is, if there were new charges against him subsequent to early 2014, he would be presumed innocent, and the commission would have had the burden of proof to overcome his presumption of innocence. The fact that there were no charges against him from early spring 2014 until his suspension in Spring Valley, the fact that there were no charges proffered against him ever in Ramapo, the fact that there were no charges ever proffered against him ever in Suffern.
Maybe he thought everybody there was competent and he didn't need to
But, Your Honor,
his power.
you're doing the same thing. You're presuming guilt instead of presuming innocence.
Well, no, I'm not presuming guilt. I'm saying that it is the job of the commission and this court to protect the public and to uphold the dignity of the judicial office. So,
I'm sorry.
you talked about a balancing. Isn't that something that is appropriate for us to consider in balancing?
Yes, but what you had, these proceedings are different from all others because the judge is invited to address the commission. And the reason for it is because the referee can't report on on penalty, only reports on guilt or innocence. And he said, what I did was wrong, and I won't do it again. And rather than say, okay, do we take his word on it, you just have to look at his record.
Well, he said what I did was wrong later, right? At first, he said I was empowering this person that he called Haitian Mafia and made excuses for his conduct, and then there seemed to be a point in these proceedings where he went with, what I did was wrong and I'll never do it again.
Yes, Your Honor. So I'm someone...
Doesn't that go to the point of, well, maybe once these proceedings are over, he'll do it again?
Well, Your Honor, I think that whether realization came to him early or late, it came to him. And it was buttressed by the fact that he didn't do anything wrong in Ramapo. He didn't do anything wrong.
But if there are
for
findings
years.
of...
I'm sorry, Your
But
Honor.
if there are findings of false testimony, doesn't that cut against the credibility?
The answer is yes, the commission can take into account the false testimony. You have to look at the nature of the false testimony. I think one of it was he said he didn't touch Mr. Joseph, or maybe he just touched him on the elbow, and there was other testimony that he may have pulled him from the chair or put his arm on him. And so that's one falsity. Is that material, not material? I don't know. A finder of fact will decide that. And the other was whether he had threatened a Mr.
In
Deere.
dispensing mercy, are we to parse what is somewhat false, not false, to your point?
No, what I'm saying is, you look at the nature of what happened, that all of it was motivated by tremendously improper judgment. Improper judgment. No venality here. He was trying to protect, in his opinion, he thought the mayor was venal. She was corrupt, and she was trying to undermine the integrity and independence of the court. And he was trying to protect it. And then later on, with the others, he was trying to, he used an interesting word, and they asked me, the commission asked me about it at oral argument, empower his staff to act professionally, not to
It's
be...
certainly possible to look at his conduct and not draw that conclusion. Do you agree with that?
No, Your Honor, I don't.
Like, there's no other way to see or to interpret this conduct.
I'm biased, so I don't interpret the conduct that way.
Well, what was he doing, Mr. Mandelker, with the tenant who had hired legal services or gotten legal services to help him? And then Judge Simon decides that they're not helping him and removes them from his case without even giving them the opportunity to say anything about that, or the tenant.
I have a problem with the premise of your question, Your Honor, with due respect, because
You disagree that that's what he did?
I disagree that they were representing the tenant.
Oh, no, I said help him. I changed it.
Because-
I understand that they didn't formally
Right.
represent him, but but Judge Simon concluded that they did and ordered them into court on very little notice, and then acted as if they were representing him and removed them from his case.
Right, and appointed someone else, and this tenant, who had been improperly locked out of his residence and was living on the street homeless, was now restored back to his premises because Judge Simon had an attorney there who said, okay, I am representing this person, and we could do the relief that the court was issuing, rather than undermine or trample on Mr. Scott's rights. He was responsible, Judge Simon was responsible for a quick adjudication of that proceeding so that Mr. Scott was able to be back in his premises and off the street. Now, does that excuse the fact that he spoke rudely to the attorney? No.
Well, had Mr. Scott chosen that legal services office to represent him, then Judge Simon undermined his ability to choose his counsel. Is
But they
that
weren't
something-
his counsel.
Yeah,
That's,
I said if he had chosen
But he
them to
didn't.
represent them.
he didn't. They said, we don't represent him. We don't represent him. Nothing, none of the papers that we've signed should be construed to mean that we represent this gentleman. That's what they said.
Well, there are different forms of representation. There's limited scope, there's full representation, there are all kinds of help that people get who don't have full
I don't want to be,
representation
I don't want to
from
be
lawyers.
flip, but I think it's like being pregnant. You either representing somebody or you're not representing
Is it
somebody.
correct that he fined him $2,500?
He fined the legal services
Hudson
25,
Valley Legal Services were fined $2,500 for it.
Yes, sir, and then he-
Let me finish. Did the judge have the authority to do that?
no.
Okay,
But, Your Honor,
go ahead.
if the remedy for a judge making a mistake of law or a mistake of fact is discipline and not appeal, then we're in a different judicial system that I know of. I'm not telling you that what he did was correct in terms of fining them, but they had a remedy, and they availed themselves of the remedy, and as I understand the record, just before the submission of the Article 78, I guess it was in the nature of prohibition, he remitted the fine.
Thank you, Mr. Mandel.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors. Edward Lindner for the Commission. May it please the Court.
Mr. Lindner, what's our standard of review?
Plenary.
We can look at this as if it was brand new in front of us.
You can. I think the crux of the matter and what you should look at is that this petitioner just lacks judicial temperament.
I didn't hear that, I'm sorry. Say it again.
Lacks judicial temperament. In the 6 charges sustained by the Commission, you see a judge who is repeatedly angry, he's impulsive, and he's willing to use his judicial power in the most petty and vindictive ways.
Mr. Mandleker's argument, as I understand it, he's willing to fall on his sword and concede all of that happened, but he said that was 4 years ago in one place and 2 years ago in another. And therefore, that's the penalty that it's the question.
Yes,
That
he
we're
thinks
aware.
it's not so bad. The Commission
He's gotten better.
disagreed.
He's
Not so bad. Not so bad
Seen the
that
light.
people lived in terror that they were going to be put in jail. Not so bad that a college student, just trying to do a summer internship so that he could have something on his resume, is sitting there for 2 hours thinking that a judge is going to deprive
What
him of his liberty.
distinguishes this case and requires removal as opposed to censure? Because that's what this is boiling down to, at least that's his
Right.
argument.
Well,
What-
I
what's
have to
the
take
distinction
issue a
here?
little bit with what Judge Fahey said, because I do think that as far as the Max Joseph incident goes, Restaino is the appropriate case, but I think by almost every measure, this case is worse. It's true that in Restaino, 14 people went to jail, and that no one went to jail here, but as the judge pointed out, that's only because the police, the sheriff's department, and a court officer refused to carry out the judge's directive. And I would just stop and think about that for a minute. The court officer refused to carry out a judicial directive. 2 law enforcement agencies refused to carry out that directive. You can look at 40 years of commission cases, and I will tell you that we have never seen that. It's unprecedented, the
Let me
level
ask you
of
this.
disrespect.
He's admitted the misconduct, and the misconduct involves a series of actions that can fairly be characterized at a minimum as erratic and maybe as lacking judicial temperament. In mitigation, was there any medical evidence offered at all?
There was nothing during the hearing. There was one question asked when he made his statement before the commission, and he said that on the advice of his counsel, he'd begun seeing a mental health counselor apparently about a month before the oral argument in front of the commission. And that's unlike Restaino. I mean, there's a lot in Restaino that is mirrored here. There was a lot of mitigation in Restaino. There was medical testimony there that the judge had these psychological stressors, which the judge had taken concrete
Well,
steps.
the job can be a hard job, and we understand that. What I'm wondering about is sometimes with the age of the petitioner, there may be different conditions that wouldn't be
There's no
brought before
testimony,
us.
there's no evidence as to that.
Thank you.
Should
Other
it make a
than-
difference, counsel, in our determination of the appropriate sanction, that most of the conduct, to my reading here, took place off the bench and within the confines
That's correct.
of the court chambers or the court offices?
That's correct. But the rules require a judge to be patient, dignified, and courteous to everyone that he or she deals with in an official capacity. And throughout this case, you see him dealing in an official capacity, running the courtroom in a way that's far from patient, dignified, or courteous. It clearly was a violation of the rules. If I can get back to Restaino, because there are a couple of points I want to make. And Restaino, I argued that case. The conduct there was clearly bad, but it really was a single instance. It was 2 hours of inexplicable madness, as one commission member called it. And that's all. There were no 5 other charges in that case. The judge's his rulings in that case were crazy, but he wasn't undignified. He wasn't screaming. He wasn't yelling obscenities about the mayor. He didn't come down from the bench and grab a college student by the arm and try to pull him out of his chair. There's everywhere that you look at this case is just really worse than that. And the only difference in Restaino that could possibly inure to his benefit is the fact that the judge there sent people to jail. And I'd ask you, if in Restaino the judge had ordered these people to jail and the court officers had taken them out into the hallway and then simply released them, would anyone seriously be arguing that it wasn't so bad that he sent all those people to jail? You focus on the judge's conduct, and you have everything that you have in Restaino, and then you've got 5 other charges, complete lack of contrition, 2 instances of false testimony. This is just worse than Restaino on every count. And then there's the Malcolm Curtis matter. I believe counsel referred to it as Mr. Scott, but it was Mr. Curtis. It's really, there's an example almost of everything that you don't want to see a judge doing in that one charge. You start with profound ignorance of the law, both as to poor person status and to attorney sanctions. You have a judge who's making a decision not to sign a poor person relief based on out-of-court rumors, completely unsubstantiated, that the tenant is a drug dealer. You have denial of due process, taking away his attorney without allowing the attorney to speak, without allowing him to speak. And you have all of that wrapped in what the legal services attorney testified was a rude and nasty tone. It really is a microcosm. If we didn't have charge 1, I might be arguing that charge 2 by itself was sufficient to justify his removal. I also just like to briefly address the notion that somehow the judge was motivated in the Curtis matter to get this poor individual back into his apartment. I'll just note that when Mr. Curtis showed up on the 26th with an order to show cause, the judge refused to sign it based on this notion that he was a drug dealer. When he finally did sign it, he made it returnable for the following week, which is hardly evidence that the judge was interested in getting him into his apartment that day.
Isn't that the problem, that his conduct seems to be motivated by his personal views of those around him?
But there's a lot of anger in this case. He's just a petty tyrant, and he's throwing around these threats of contempt. And I think you see that in Curtis, because it's only after...
Why doesn't that exhibit itself in any of the other courts?
All I can say is, Your Honor, we don't have any complaints. We have nothing in the record. But the absence of evidence isn't always evidence of absence.
How does a county executive raise charge? I think it was charge 5?
Yes.
Could compare with these other charges.
It's a serious breach of the rules prohibiting judges from engaging in political conduct. You have here a judge, and first, there's a bit of anger in this charge as well, because he and Judge Freed were friends originally back in 2009, and they clearly had a falling out. In 2012, Judge Freed was involved in the Maxery Joseph incident. Now, it's the following year, Judge Freed is off the bench, and he's running for county executive against Mr. Day. And there's an issue in the case as to how the county is going to deal with substandard housing. And Mr. Day is making the claim that the Judge Freed, then Mr. Freed, wasn't tough enough on slumlords. And he gets some information about this, and he calls up the petitioner, who happily tells him this story about how they went together and they looked at this office space, and the petitioner, our hero, tells him, we can't take this space because this man is a slumlord and he has cases in front of the court. Well, Mr. Day says that this is really explosive information. This is what exactly he needs. He asks for permission to use the judge's name and to quote him in this political campaign, which he does. Mr. Day calls him back a second time, and he reads him the statement. He's had time to think about this, but he's happy.
If that were the only charge would we
Censure.
be looking at, we would be
Censure.
looking at
It's a serious censure. It's in the neighborhood of matter of Rob. I shouldn't say that so quickly because I don't know if we develop that what the commission would say, but it doesn't seem to me that it's quite at the level.
Well, if we were looking at that and the Mr. Joseph incident, would we still be talking censure, or would we be
Absolutely.
talking something
Max
else?
Joseph by itself, when you look at Restaino and all the mitigating factors that were there, all of the arguments that he's making now, even if you believe them, were made in Restaino when they weren't enough. I'll just end by saying, in matter of Bauer, you said sometimes contrition is insincere and sometimes no amount of it is enough. And that's exactly this case. We've laid it out in our brief, and there's every reason for the commission to have had doubts about the sincerity of this 11th hour epiphany, this contrition. All through the hearing, his initial brief to the commission, he's insisting, even in his first brief to the commission, that the Max Joseph incident was the fault of the clerks, who were antagonistic against him. It's only when present counsel is hired that he suddenly changes his tone and he's filled with remorse. And if you look...
Is it that he can never regain public confidence? Because that's why
That's
he's
what you
showing
said in
those election
Restaino,
results,
and I
right?
think that's true. I think when you get to the point where law enforcement is refusing to carry out a directive from the judge, that public confidence in his ability to do the job is broken.
Thank you, counsel.
Thank you, Your Honor.
Mr. Mandelker?
Another way of looking at it is that they were trying to protect the judge from getting into even more trouble. The incident with the tenant, my friend said that the order to show cause was returnable a week later, but Judge Simon advanced it so that it was returnable the very next day. And he brought the landlord in, the correct landlord, so that relief could be awarded that very same day.
You know, Mr. Mandelker, on that, what strikes me about it is it does seem that the representation or help that was being given to Mr. Curtis was incompetent or inadequate. And so, but a judge in city court or town court deals with that all the time. And so we're talking here about temperament, not about a mistake of the law. I think you're right about that. That part of it is, it's not the mistake of law that really matters here. It's about the temperament and how it was handled.
Correct. And if you're balancing the fact that he, quote, removed the attorney versus the fact that it was so that he could provide the ultimate merits relief to the litigant, I think that is something that's important.
That was
Fine.
only after he determined that he liked the tenant after all, that the rumors that he'd heard, which allegedly caused him not to sign the order to show cause, were untrue.
Don't we want judges to be able to take in information as it comes and act on the information, and rather than be closed-minded?
The
Well, I
point,
think the
the
point
point,
is you don't
Mr.
wanna start with from
Mandelker, is
bias.
that he was
I
closed-minded to begin with.
Well, but
Or from bias to
Yeah.
begin with.
Well, I don't think there was the bias there, because he went out of his way to get relief to this tenant, out of his way to make sure that this tenant...
After he set a date a week into the future with, which looks like it ensured that this person would be on the streets for a week?
And then advanced it within a few hours. Advanced it within a few hours. And the first thing he did, brought the man in, gave him poor person status. That's what he did. Last point that I'd like to make. My friend said the absence of complaint doesn't mean anything. But that's not what this court said in Watson. In Watson, one of the things you relied on in reducing the penalty from removal to censure was the fact that for 2 years, Judge Watson had served on the bench, no complaints, no problems with him. I think it's very easy to say, let's ignore the reality that Judge Simon has served 5 or 6 years in Ramapo, never with a complaint, that he was selected to serve in Suffern by the administrative judge in the 9th District, and that he was reelected in Spring Valley 50% of the vote, it's a small village. If he was so out of control and so biased and all the rest, and the public had no confidence in him, how would they have re-elected him? 50% of the vote, three-person race, no further complaints. We ask the court to exercise its powers of review. It's plenary. This is one of the times when the judicial disciplinary process may have worked, because you've gotten a change of conduct. That's the important thing here. There's a change of conduct. And isn't that really, we're not after punishment, we're after a change of conduct. So on a going forward basis, the public will be served, and the public will have confidence. And that's what you have here. And
Thank you, Mr. Mandelker.
thank you.